And welcome to our webinar today. This is Optima Healthcare Insurance Services webinar, COVID-19 litigation, laying the groundwork for uncharted territory. I'm Millie Mastromati with Optima and your program moderator today. Today, we're going to be discussing what the COVID-19 litigation landscape looks like right now and how it may evolve. And also importantly, what you can be doing right now to help in the defense of potential cases surrounding COVID-19. But before you get started, I will do a little bit of housekeeping. I'd like to request that you keep your lines muted until the Q&A session. You can chat in questions anytime during the presentation, but we'll address all of them at the end. And also, we've moved to the Zoom platform, which I'm sure most of you are very familiar with. And so you have complete control over your view. And so if you want to do presenter view or, you choose how you want to look at it to make it as helpful as you need to. And you'll also notice the red dot in the corner. That means that we are recording. I am recording this for you and only you. So, and you, just the registrants will be getting a link to this recording. To introduce our speakers today, both of them are from the law firm of Lewis Brisbois. Lon McIntyre is a partner of the San Diego office of Lewis Brisbois, and Lon is the vice chair of the appellate practice group and has taken on the lead role nationwide for the firm on COVID litigation strategies. Also speaking is Brian Reed, whom you may remember from last year in his excellent presentation on elder abuse for us. Brian is a partner in the San Bernardino office of Lewis Brisbois and is a member of their long-term care and elder law practice. Both of these attorneys have extensive experience in healthcare litigation, and I encourage you to go to our website to view their complete and very impressive biographies. For now, welcome Lon and Brian, and I'll pass the floor to you, Brian.
Very good. Thanks so much, Millie, and thanks for having us back. I'm really privileged to be joined by Lon McIntyre, who is co-chair of the firm's appellate team, and her team is taking the lead in our efforts to front the legal challenges to the claims as they come in. She's very knowledgeable about the PrEP Act and its application. We'll be getting into that. Before I start, I want to, since this is being recorded, I want to have an agreement amongst all of us that this program is part of a quality assurance network for the members insureds of Optima. It is attorney-client communications, as far as I'm concerned, and as far as all of you are concerned. We'll be giving some tips today, some insight about the litigation, and at no time should this recording be shared outside of members of your quality assurance teams, okay? Could be someday that there's a discovery request and that any discussions that involve, possible litigation are requested. This is privileged and confidential. And as I tell my clients as we're prepping for depositions, the QA privilege is a very strong one, as long as we protect it properly. We think of the quality assurance privilege as an umbrella, shielding us from the rain, and anything that happens underneath the umbrella stays dry, stays privileged. If it's shared outside of the umbrella, it gets wet for the world to see. So please keep that in mind. Thank you. So let's go to the next slide. Just a brief overview of what Lon and I will be addressing today, involving the current state of civil liability claims, which they are coming in related to COVID-19 infection, and a discussion of the risks, that some of which are obvious, some which may not be obvious to hospitals and long-term care providers. We're going to be talking about the best practices for defending the claims, both from a legal perspective and then where we're invoking existing legislation and immunities, or attempting to do that, and then risk mitigation steps, which are the hope a takeaway for you that that you can implement now to be as prepared as possible to help defend yourself, help your lawyers defend claims as they come in. Okay, let's move on to the next slide. So our firm right now, we're a national firm. We have over 100 open COVID claims for healthcare providers. Many of them are notices of claims, and I'm going to talk about that a little bit later, but we do have quite a few cases that have been filed, served, or being litigated. COVID-19 claims are going to be, there'll be crossover for sure, but some very different areas of focus in those lawsuits. We're looking at claims of supply management, availability of supplies, testing protocols, of course, diagnosis. I think issues with regard to ventilator usage, overusage, or rationing might be, will certainly be issues. Community spread. A big area of focus will be the protocols that the healthcare providers were adopting and following and proving that they were being followed. Failure to warn, delayed identification, treatment, community spread. All of those things are going to be and are showing themselves to be issues in this litigation. The next bullet point, that they're more factually complex and involve an evolving standard of care. Of course, when a healthcare provider is sued in a negligence case, the question is whether they complied with the standard of care. We hire experts who, offer opinions that what the healthcare provider did meet the community standard, did what a reasonable provider would do in the same or similar situation. Of course, we're dealing with there's never been a similar situation as long as any of us have been around. And during the course of the last year or so, the situations have changed dramatically with surges and different protocols, different mandates from the government. So why are they factually complicated? Because we're going to need to evaluate the timing of whatever the claim involves. This particular patient claims they got COVID. When did it happen? Was it a year ago, April 2020, or was the alleged exposure in November of 2020? Clearly, the response to that is going to be different, because I'm sure all of you had evolved or altered your protocols over the course of time. So this evolving standard of care is going to be, it's really almost no standard of care. And I'll talk about that a little bit more. So we're already in the process of identifying new and different expert witnesses than we have focused on in the past. So again, a crossover for sure, but we're talking to supply chain experts that can talk about the availability or lack of availability of PPE, ventilators, medications. Of course, we'll be working with public health experts, epidemiologists, infectious disease experts, part of this discussion will be, what can you do now to help those experts support you later? And then we're also, of course, on the legal side of the equation, attempting to utilize existing legislation, as I mentioned, the PrEP Act and some other statutes. But let's go ahead and move on to the next slide. So there's ongoing discussions and efforts concerning immunity. Immunity is not an unusual or new concept in the area of law. In California, we have the Good Samaritan statute, which is an immunity from liability if someone falls in the role of providing aid in an emergency situation. Immunity and different, there's, I think Lon and I are talking, about 17 states have passed some form of immunity with regard to COVID liability, COVID claims. California has not, except there was a governor's order related to the administration of the vaccine specifically. And so, and here we're seeing some, possible complications from the vaccine. So there may actually be some immunity if it relates specifically to administering the vaccine. But efforts to get Governor Newsom to sign an order that more broadly offers immunity have, initially there was a lot of promise to that. I won't comment on the state of California politics, but there doesn't seem to be as much traction there right now. What we're seeing with immunity statutes is mostly not a complete blanket or shield from liability, but it'll set much higher standards for a plaintiff to move forward, showing recklessness or gross negligence or willful misconduct. One is coming down in Texas right now, and it basically says that if a healthcare provider or institution made good faith efforts to follow the government's pandemic protocols, they can't be sued. And so whether we wind up with immunity or not, that ability to prove our good faith efforts to comply will be critical to either getting the case thrown out or to defending it. There was an issue about waivers, and some of our clients have been using waivers or disclosures separate and apart from admission agreements or conditions of admission, but just a separate document where it's acknowledged that there's a pandemic, that there are risks, and building in some waiver language. The enforceability is questionable, but those were our clients are saying, like, thinking it can't hurt. And it certainly makes sure that the patients are aware of the risks. Also, there was an issue of waivers as it relates to staffing requirements in healthcare facilities, long-term care. And, to the extent that those waivers have been utilized by the healthcare providers, then I think it's incredibly important to keep documentation of the efforts to staff at the expected level, or at least at the levels that you could reach. What efforts were made to retain or replace staffing? We'll talk about the risk management a little bit in a little while. Let's go to the next slide. So the current dynamics of COVID-19 claims are interesting. One of the key aspects of really any lawsuit brought against a healthcare provider, and particularly when there's elder abuse claims or other not straight medical malpractice claims, is who is the plaintiff's attorney. And what we're seeing in our cases so far is interesting, because for the most part, we're not seeing what you might say the regular players. The attorneys that make their living, earn their careers, are focused on suing. The healthcare providers, long-term care providers, aren't necessarily the ones that our clients are hearing from when it comes to potential COVID claims. The Barnes firm, that national firm we see advertised on TV, is showing up. There's very notable experienced plaintiff firms in California that don't typically do medical malpractice or elder abuse litigation. They're showing up. And honestly, frankly, in conversations that I've had with those lawyers who I and my colleagues recognize as players, they don't really want to they're expressing a hesitancy to taking COVID claims. I think for a number of reasons. One is that there's a recognition, and I'll talk about this, that there might be a little more sympathy for a healthcare provider in the context of COVID than they care to deal with. Of course, they try to make us the bad guys. And right now, our healthcare providers, the frontline workers, they're the heroes. They're being celebrated. There's also some pragmatic aspects where the risks of COVID-19 litigation just devastating the healthcare industry if they become overwhelming and force bankruptcies. It creates a crisis. And my colleagues on the other side, the plaintiffs' attorneys, many of them know that the last time there was a healthcare crisis in California, I think we have some visitors, some participants from other states as well. When there was a healthcare crisis, that led to MICRA, and that has been a burden for the plaintiffs' bar, a benefit for our side for sure for decades. So there's a hesitancy there, and what that means is that the people that are bringing the claims may not be as sophisticated, may not understand the delivery of healthcare, the challenges, the language, and those cases can be difficult to defend just because there's so much educating that takes place. We have to educate them, how staffing works. What is an LVN? What is a DON? I mean, it can be as simple as that. So the cases are definitely coming in, and we're seeing a different breed of attorneys. With regard to arbitrations, some of our clients are opting to try to enforce the arbitration agreements. Others are deciding not to. And this will be a case-by-case, provider-by-provider decision to be made with your counsel. The biggest concern with use of arbitration or enforcing arbitration is the lack of appeal. A binding arbitration has very little, an award in that context has very little ability to be challenged on appeal. And there's a lot of, as we're going to talk about here very soon, a lot of moving parts, a lot of unanswered questions in the courts about statutes, about applicability of statutes, about immunities. So there's all the benefits of arbitration are there. The reason we ask for it in certain cases, hopefully not a runaway jury, keeping things under control, maybe keeping costs down, but not always. But that lack of appeal is a significant factor. Okay, let's move to the next slide, and I'm going to turn this over to Lon to bring you up to speed on this PrEP Act, what it is and what we're seeing.
Thank you, Brian, and hi, everyone. The PrEP Act has been an interesting development in this area as it has expanded over time since it was originally activated by the Secretary of the Department of Health and Human Services. The PrEP Act is an immunity statute, as Brian has mentioned. It was originally enacted to provide immunity to vaccine manufacturers and others who provide medical countermeasures to address a public health emergency. And the immunity was to encourage the rapid deployment and development of those measures. The Secretary of the Department of Health and Human Services, who during this pandemic was Secretary Azar, is authorized by Congress to declare a public health emergency and to define the application of the PrEP Act to that particular emergency. So in this case, the PrEP Act has been activated effective February of 2020, and it covers covered persons, covered countermeasures, and certain covered actions, which I would like to talk about. One of the actions is that is not covered by the PrEP Act immunity statute is willful misconduct. And there is a specific provision in the PrEP Act that says if you're alleging serious injury or death as a result of willful misconduct, you can bring a claim in federal court in the District of Columbia, and you're limited to that particular venue for a decision of your claim. And there are a lot of limitations on what damages can be recovered. You can't get attorney's fees, and there's a higher standard of proof for those claims. Otherwise, if you read the PrEP Act, it appears to give really broad immunity to a number of different people, countermeasures, and activity, which can include non-use of countermeasures in certain circumstances, which I'll talk about in a minute. So the PrEP Act coverage is intended to cover a sort of a defined group of persons, which are generally healthcare providers in the setting of long-term care, skilled nursing facilities. The PrEP Act has been interpreted to cover program planners and qualified persons. Those definitions have been interpreted by the Secretary and his Office of General Counsel to be covered by the immunities that are offered in the statute. The question becomes, what are considered covered countermeasures? And there are 4 definitions of those covered countermeasures. And again, we're in the beginning stages of defining legally what constitutes a covered countermeasure. It can be a drug, a biological product, or a device to prevent, mitigate, treat, or cure, or limit the harm. So we're seeing allegations such as failure to provide PPE, masks, gowns, gloves, failure to test for COVID, failure to provide N95 respirators when they should be used, as those kinds of things are considered covered countermeasures under the PrEP Act. At least that's the argument that's being made for now. We're also talking about and debating in these cases whether what constitutes covered conduct. The statute talks about a use, distribution, administration, or dispensing of a covered countermeasure. And the question is, does a healthcare provider like a hospital or a long-term care facility, are they in the business or engaged in conduct that would fall within that definition? One of the big issues that keeps coming up with the covered conduct is whether or not failure to use these covered countermeasures would fall within the PrEP Act. And the Secretary's Office of General Counsel has published a number of advisory opinions in response to public inquiries about the application of the PrEP Act, and has said in an advisory opinion issued in January of this year that non-use can be considered a covered conduct. And that would be, for example, if you're making a prioritization or purposeful allocation of covered countermeasures, that would fall within the statute, within the immunity statute. I thought I would just briefly talk about the current litigation that we're seeing concerning the PrEP Act, and we're again in the early stages of our legal challenges. But what the strategy has been is that there have been a flood of cases in state court. They're all being filed in state courts around the country. And our strategy has been to remove these cases to the federal courts, because we think that the federal venue is a better venue for decisions about these kinds of issues in terms of how do you apply federal statutes and how do you interpret them, and the federal courts are better equipped to make those kinds of decisions. So we've been removing the cases. It's an easy thing to do. Anyone can remove pretty much any case. The question is, does it stay there? Does it stay in the federal courts? And that's where we are seeing plaintiffs filing motions to remand the court cases back to state court in an effort to perhaps take advantage of a local forum that might not be so neutral to the federal legislation, or might not be so inclined to apply the immunities that the PrEP Act affords. So the motions, the opposition to these motions to remand that we're fronting is based on 2 legal arguments. First, that the federal officer statute applies. And that would that's a particular statute that says if a person or an entity is acting as an agent of the federal government, that they're entitled to be treated as a federal agent or a federal officer and have their case heard and defended in federal court. So the argument for us is that these healthcare providers and long-term care providers are part of the front line that has been addressing the pandemic under very specific and detailed directives and guidance and regulatory oversight into how you do everything in response to this COVID pandemic. So that is one legal argument that we're making. We're also arguing that the PrEP Act completely preempts state law claims, and that every claim should be heard in federal court as a complete preemption of any intended application of state law in these cases. So we are now in the process of seeing a trend towards remanding these cases to state court, but we have at least one favorable decision, the Garcia decision, where the court said, you know, the advisory opinions have come out, the secretary's made this declaration adopting those opinions, and we have to defer to what the secretary says. And the secretary says that these cases are intended to be decided on a nationwide basis in federal court. So we have that favorable opinion, and we're hoping to obtain more. But you know, a lot of these remand motions are being granted and sent back to court. So we're now in the process of appealing those rulings. We currently have probably the first case that's going to be heard by the Third Circuit Court of Appeals in Philadelphia. Sometime in June, we'll be arguing that case, and we'll start getting other circuits weighing in as we proceed with these appeals that we have throughout the country that are being asserted to try to keep these cases in federal court. So I wanted to also make clear, and I know that Brian's going to address this as well, is that even if you are sent back to state court, the PrEP Act immunities can still be asserted as a defense to these claims, along with all other available immunities that Brian had mentioned.
Right, and so so we're fighting to keep them in federal court. Or the next question is, what are the appellate courts going to do with that question? I heard from a partner in Texas yesterday who got reprimanded by a federal court judge who granted the motion to remand, sent it back to state court, and said, you know, I'm going to start sanctioning you guys for removing these cases because the consensus is that it shouldn't be in federal court, which is that's a pretty aggressive position for a judge to take, but it's not unusual. But a significant difference between the judges in federal court and the judges in state court is that federal court judges have lifetime appointments. They don't go up for election or reappointment. Once they have that position, they stay there unless they get impeached. Where our state court, at least in most states and here in California, most counties, you get appointed to the bench by the judge, and then every 6 years you have to run again. And so I don't like to think that judges make decisions based on popularity contests or what's popular in the community, but that's another consideration. So we're certainly circling the wagons around the Garcia case, which actually came out of Santa Ana, and we'll see. We'll see how that all moves ahead. What the state courts will do with the PrEP Act remains to be seen. We have not gotten that far. Okay, thanks, Lon. Let's move on to the next slide. So talking about some of the risk management strategies to implement, and I've touched on them. I did want to point out one other important point about what's been going on with the law in California. Last year in early April, the governor and the Judicial Council issued an order tolling statutes of limitations and it ended up lasting for about 6 months. those of you that are familiar with the notice provision, 340.5, CCP 340.5, where you have to give 90 days notice before you bring a medical malpractice lawsuit, that has been a wealth of litigation for decades. 364 notice, sorry, 364 notice. Litigating whether the complaint's timely or not. This is a broad tolling of statutes of limitations. It's more than likely going to mean that a case for medical malpractice, the statute of limitations for the foreseeable future is going to be about a year and a half. I did have a demur challenging the timeliness of a complaint this week. Case was filed 4 months late. The court overruled our demur, allowed the case to go forward. It found the plaintiff's attorney said, look, they locked the doors the day we were filing the complaint. We couldn't get it in until June. The court gave them the pass. So it's going to be, but part of the point I'm making is don't lose sight of the fact that these cases, you might get them now, or you might not see them for another year or more. So when it comes to risk management strategies, they're going to sound familiar. They're going to be even more, I'm going to be more insistent about these things. Careful documentation and preservation of all evidence, obvious and otherwise. If these cases end up going to trial, we're looking at 2 or 3 or 4 years from now. And we need to be able in trial to recreate and remind our jurors of the crisis that we lived through. It's hopefully going to be well in the rearview mirror. Life's back to normal. I think our society is quick to forget. And so I'm asking you to be thinking 3 or 4 years in advance to help us tell our story. So obvious evidence is, of course, the chart, right? That's easy, and that will be preserved. But as we talk about evolving standards of care during the COVID crisis, we need to show, well, what were we doing in May of 2020? If that's the key timing of the case. We need to have, we're going to want to see what communications were taking place inside the hospital or the nursing home or the assisted living community. Text messages from the chief nursing officer or the DON to other staff, or from the administrator. Anything that we can point to show what the situation was and what we were doing to deal with it. I'm a fan of demonstrative evidence. What about pictures of signage that's up on the walls and on the doors that we can show the jury? These are the efforts we were making. Pictures of your precautions in the hospital or in the nursing home. People in the gowns and the things we see on the news. Photos of those, of all of that, pictures of notices or the actual notices. Thank you. I love to have a happy file, right? It might just be that the person suing you or the family of the person suing you actually had someone in their own family that sent you a thank you note, recognizing the challenges, or they bought sandwiches for the staff at the same time that they're now claiming that we did something wrong. So those happy files need to be preserved. All facility letters and the AFLs, of course, those get replaced, right? As they get updated, and we have the catalog of those, but those would be very critical to helping us establish what that standard of care was at the particular time. Any specific communications you've had with like your regulatory agency, the Department of Public Health, or local public health, and if they came into the building and gave you directives or orders or requests, we want to be able to document that. A good way to do this, and I know it sounds overwhelming, but is to just create a chronology, appoint someone to be your historian, and have a chronology that just walks through and here's the April 2020 file with the pictures and the emails and the interventions, the policies, the training that was taking place. So we just need to preserve all of that. The more preservation that happens, the more compelling the story we will be able to tell a jury way down the line. And the more compelling you'll be able to tell your story, because you'll have it there. You'll be able to remember what you were thinking, what you were doing at the time. The next bullet point is a quick and complete response to attorney inquiries. So the way, what we're seeing right now, I said we have a lot of open cases, we have a lot of notices, and a notice looks like a letter from an attorney, and it says, this is to demand that you preserve all of the following information. It's a preservation of evidence letter, and it's very significant. It's significant because they're actually helping us do what I'm asking you to do, number one. And it's going to articulate all the things they want you to keep track of. Videos, right? Once you get a letter like that, if documents that fall within the categories they request, or evidence, any evidence, documents, videos, pictures, communications, whatever, if they go away after you receive the letter, then that can be used as significant evidence against you in a trial. The destruction is called spoliation of evidence. And the jury is allowed to have significant inferences, make significant inferences if all of the electronic communications about staffing of April 2020 are now gone after we asked you to preserve them. They can make inferences that are not favorable. And we want to have that stuff anyway. So when that letter comes in, there should be a system in place in your facility or community to notify the department heads. We've received a preservation of evidence letter. Please make sure that you segregate, isolate, and do not destroy anything. And that includes anything that's destroyed pursuant to normal destruction protocols, preservation protocols, and videos that get overwritten. Those are really something to keep an eye on. So that's what the letter says, and then they'll ask you for the records. I encourage you to, if a letter comes in, let the carrier know, your risk team know, and prepare a really good response, and I mean a thorough production of documents. I want you to look like you've got your act together. You're on top of it. And if you are thinking of, bringing these lawsuits, we're not going to be a good target for you, because we know what we're doing. One of the things that sets off alarm bells in a plaintiff's office is when they request a chart and it's clearly not complete. They only produced a copy of the electronic record, not any parts of the hard chart, or vice versa, or we forgot to click a tab, and so none of the ADL documentation was produced. If it's not complete, it raises a red flag. So as I mentioned, a specific facility-specific chronology of communications. Each of you have been through this crisis, and I'm sure each of you have had your own challenges along the way. They're probably similar but different, and managed similar but different. Going all the way back to that thing I mentioned about immunity, good faith efforts to comply. A good faith effort that we can show, even if it wasn't successful, or somebody got COVID, or somebody passed away, we're gonna do very well if a jury believes we were trying our darndest. We did everything that we could, and that means not having gaps or blanks or creating issues that can make us look like we're trying to hide something. Don't forget to preserve all that screening data. I come into the office and they take my temperature and make a note. All of that needs to be preserved for a long time. Okay, let's go to the next slide. And Lon, did you have anything you wanted to add to that? Anything you're seeing from the appellate side that is seeming to be helpful or missing?
Just one aspect of that is the presence of any kind of like the National Guard or a surveyor or somebody who is deployed outside of the usual structure, who's there at the facility or remotely directing the facility how to do certain things, what patients to accept, where to move them, et cetera. That can be very helpful to our argument that we were acting at the request of a federal officer and can help us with the jurisdictional issues.
Yes. Okay. Good point. Good point. So as I talked about some of these, but as we're thinking about that chronology and documenting what we're doing, here are some of the areas that you to be focusing on. Infection control, of course, is critically important. You know, we want to compare. We want to show that we had a good infection control program and protocol going pre-COVID, and the changes that were made. And something that just popped up into my head, I see some familiar names on here. You know, a great evidence of efforts being made and interventions are invoices, right? A lot of you have spent significant money on PPE, on ventilators, on the plastic sheeting. You know, that file of invoices is great evidence of the money and the being spent, the efforts being made. You know, the distribution of PPE, that as I understand, you know, has evolved, and it's based on availability and how long can you use a N95 mask. And so, you know, tracking all of that, efforts to get new PPE, the testing and vaccination, and now vaccination strategies, you know, we want to preserve that. Training is really, really important, and it's not always as well documented as we might like it to be, because a staff training could be a one-on-one. You know, this patient has these special needs, and so a few of the nurses are, you know, gathered and told. Hopefully that's getting entered into the chart. I was working on a case, and a care plan on falls had a specific intervention. It was in service to staff regarding this resident, which is just a great entry. Tracking our visitation policies, what we're doing to prevent introducing COVID into the building, all of the regulatory documentation, the housekeeping strategies. Those people, as you all know, just worked incredibly hard. What was done to keep them safe, their specific training, backup support. So you know, it's a huge task, and it may feel a little overwhelming. The thing is, it all exists, except for maybe the timeline. What we're asking you to do is just start organizing it. The more organized you can be, the stronger our defenses will, our ability to defend you will be. I think that was the bulk of what I wanted to address. Lon, did you have anything that you wanted to add at this point?
Yeah, I did have one thing popped into my head that I forgot to mention as part of the PrEP Act scheme, is that there is a compensation fund that's available for persons who are claiming that they've been injured or harmed by use of covered countermeasures, or in some cases failure to use them. There is a special compensation fund. It's kind of a pre-funded, almost no fault type of process, similar to perhaps a workers' comp claim. And some people are starting to try to take advantage of that instead of filing lawsuits. So that is another component of what's going on in this field.
Yeah. So why don't we open this up for questions? I expect there's quite a few questions, and we would be glad to address those for you all.
Okay. So you can chat your questions in if you want to unmute yourself and ask a question. That's also that's also an availability for you. Right now, I don't see any questions that were chatted in during the presentation. So while we're, maybe waiting for people to type something in or chat it in, I just have a quick question about when you were talking about the plaintiffs that are, that they're not the regular players. Do you think that those regular players are waiting until our memories fade and that, maybe healthcare providers are heroes now? I mean, they are heroes, don't get me wrong. But, I mean, like, how the news cycle is so small and people's memories fade. Do you think that those regular players are waiting?
It's possible, it's certainly possible that we'll see them popping up later on. I hate to say it this way, but I kind of think of it as they don't want to kill the golden goose. It's these lawyers that make a living suing healthcare providers, nursing homes, they do quite well for themselves, and I think that they have. Honestly, I think some of them don't necessarily object to some form of immunity to better protect and preserve this industry. Now, maybe, and so it remains to be seen, but they've got a good thing going, and they don't want to spike another micro type crisis by overwhelming the healthcare system with lawsuits, and force the legislature to do something drastic or dramatic to keep the healthcare industry stable and solid. Now it could change. I mean, there are other considerations, in terms of won't get into it too much, but where the funds come to defend the cases, where the funds come from to pay judgments. That's another consideration. I think that from a plaintiff's industry, they're looking at.
Okay, thank you. I don't see any questions in the chat box right now. Would anybody like to ask a question verbally? And while we're thinking about that, I'd like to remind people to go to their to the email that they got on Tuesday to complete the evaluation and connect to either the electronic form.
When you're thinking about your timeline, your facility specific chronology, noting the first incident of COVID. When did you see it, and where did it start, and what does the contact tracing suggest? I can mention another very, very significant defense as we talk about contact tracing, and something to keep in mind as we defend these cases. There's aspects or elements of a lawsuit. Are we liable? Did we do something wrong? Were we negligent? Right, and that's where we talk about standard of care. Did we do something that fell below the standard of care? I've talked a lot about that. There's also a huge question of causation. If somebody wound up getting COVID, is it linked to our conduct? Did they get it, from a visitor, or did they pick it up before they ever, from some other source? In our long-term care facilities, people going out for dialysis, they're being exposed to other people and environments. So that notion of contact tracing for your own community, where, what were you able to determine will be important too. Is this a resident that had multiple visitors? And did those, what's the status with those visitors? So it's quite an undertaking to track all of that.
Okay. So we did get a question in through the chat regarding if the claims you are receiving now, are they totally unfamiliar to the defendants, or were these issues on their radar in the incident reporting systems, or from patient family complaints, or from other sources to the organization to get alerted to potential claims?
Yeah, so as I understand it, and from what I've seen, they really don't know who's going to sue them. I mean, they know who's, for the most part, who's dealt with COVID, but which of those particular COVID cases are going to result in a lawsuit? I don't think that our clients have had a lot of notice about that. Certainly, some of them had complaints, and inquiries and uncomfortable discussions before the lawsuit. But for the most part, you just never know who it's going to be. You don't know. But if you do know, if you have a sense, then the sooner you start documenting your defense to that particular claim, the better. No question. Let your carrier know, work with risk management, and get your arms around it as quick as you can.
Okay. So I don't see any further questions, and I really appreciate you, Brian and Lon, taking the time today to share this information with us. It's super valuable. And I'd like to thank all of our participants for the work that you do every day. You are making a difference, and thanks for taking time to spend with us today. I'm going to conclude I guess I should ask Brian, do you have any closing remarks?
I would say that this last year has been unprecedented for healthcare, and the next few years is going to be unprecedented as well from the standpoint of litigation. And we are there to, and my colleagues in the defense, there's great lawyers that do what I do, and what Lon does. It's going to be a long journey. We'll work together, and I think overall we're going to be just fine. But let's take the steps now to be ready for what's very likely coming down the pike.
Okay.
All right.
You know what? Actually, one more question did come in. About where should the timeline or chronology of communications reside?
That's good. Yeah.
Okay, go ahead.
That actually had crossed my mind, and then I lost it. Kind of circle back to what I said at the very beginning. This needs to be a quality assurance tool. It needs to stay under that quality assurance umbrella. It should, and remember, the quality assurance team, in a deposition, who's the members, and you'll list out department heads or whatever, but the quality assurance team shifts based upon what the issue is, and it could include a charge nurse that typically is not part of QA, but they witness something, and they're brought in to talk to the quality assurance committee. They are part of the quality assurance team at that point in time. They're under the umbrella. So I think the chronology should be managed by risk management. It should say a quality assurance document prepared in anticipation of litigation, because that's really what you're doing. I'm your lawyer. I'm telling you to prepare it so that it is in this vault and can be used for your defense and not by the plaintiff to pick holes in it. So I really appreciate that question. Really pay attention to the QA aspects of this.
Perfect. Okay. All right. And so if anybody thinks of a question later, just reach out to me or your risk management consultant, Alina or Regina, and we'll get your questions answered. Okay. Thanks so much, everybody. Have a great day.
Thanks for having us.
Thank you
Take
for
care.
having us.
Bye-bye.